those who implement the civil service. You are giving me a gearbox which I can't change. Either I drive in only gear number 1. I can't speed up the car. I can't go to gear 4. All the levers of the gear movement are in somebody else's hand. Go to the LG.
Either he relies upon or he does not rely upon.
Very well.
Because I have an answer.
Now, Madhus,
They are
in the light of
factually
this,
incorrect.
I am concluding.
And as per the contemporaneous record, they are incorrect.
Either I am. Anyway, let's leave that.
Don't say something and say that I am not relying upon.
Either I am not living in Delhi or Mr. Mehta is not living in Delhi. Both of us can't be living in Delhi.
But we take it that what you
Anyway.
are giving us are hypothetical illustrations of what may happen if we don't accept your.
From all India services and central government services, who serve, one thing I must clarify. All that I am seeking, actually, I cannot imagine a more minimalistic issue. All that I am seeking in this case is, this is important before I read this section.
Yes.
All that I am seeking is that civil servants, once they are there serving in the UT of Delhi, where to post them? In Department X or Ministry Y?
Yes.
All that is involved is a very simple thing. Once a civil servant is posted in NCT, working in NCT, A, where department, where ministry to post him, B, when and how to transfer him, and C, related obviously, is which work to allocate to him, which work not to allocate to him. And D, if Lordship wants to add, reporting to which minister. Now, I am not seeking disciplinary power, that is not the case. Over them, whatever are their own rules will govern. Well, I hope my Lord is.
Yes.
Normal rules govern the civil service, they will govern. Disciplinary power may be in the Ministry of Personnel, etc. I am not concerned with that. I am saying that you cannot prevent me and should not prevent me for good governance from posting to a post, giving the nature of work and transfer. Intra-state, intra-NCT. That's the only case. One sentence. What am I arguing about? Only posting to a particular allocation of work and transferring within the state. Please keep that in mind. That I submit is unacceptable. Your disciplinary rules can have anything. You can go to the President of India, you can go to the central government, don't care. One more sentence, please. Joint cadre means that it's an all India cadre, but the posting is in a state or a UT. And the UT will then decide intra cadre how to allocate you. That's the only issue. Now read 41 onwards. Government, civil servants from the all India services and central government services who serve in the government of NCT are under administrative control of the government of NCT in respect of postings and transfers. Does my Lord have it?
Yes.
Insofar as all India services and the personnel of central government services who serve in the government of NCT are concerned, the position and respect of control over them will be covered by the statutory rules framed in respect by the government of India as they apply to the NCT. It is submitted that the net result of these rules, as will be explained hereafter, is that while making a person available for services in NCT, you can make him available for Arunachal or Bihar or West Bengal is your choice. Once he's available to me, then what happens is the question now. Available services in NCT is the function of the joint cadre authority. This itself brings in the UT1. The actual posting of that officer to any department in the government of NCT is within the domain of the government of NCT. The above flows from the cadre rules of, just let us read through it, just mark it, I'll show them in a minute. We'll save an official time rather than jumping each time into the rule. It is clear from the 1954 rules and the 1972 rules, that is the joint cadre and the IAS cadre. The function of the joint cadre authority under the All India Services joint cadre rules is under 5.1 to determine the names of the members of the All India Services who may be required to serve from time to time in connection with affairs of each of the constituent states and the period or periods for which their service shall be available. Now, unless you say in the same breath that states here means no UT, which you have said just now you don't mean, then Manoj, UT has to be covered because services are there in the UT also. If you read it literally and state means only state, no UT, Manoj, that would be a ridiculous situation, my humble and respectful submission. And they are disclaiming.
So we are restricting only to the posting and transfer.
My heading says that.
With respect to the officers who are allocated to the Delhi cadre.
The answer with the deepest respect is an emphatic yes. And I have taken care to put that in my heading. Your Lordship doesn't mind.
Right.
The heading above 41. And fellows, there is nothing else required because I am not supposed to go and say that in the cadre, this man cannot go to West Bengal. He must come to Delhi. Or your Lordships cannot have him serve in the Supreme Court on deputation, but he must come to me. That power I am not asserting.
The cadre controlling authority can say, well, we're pulling
And
this.
that itself is a joint cadre.
Sending him somewhere else.
I am grateful. That itself is a joint cadre controlling authority. It's a mix of everybody.
But
The
once
state-
they are, it's a limited point that once you are here, then the government must have the authority.
Intra. I'm very grateful. That is important to narrow down. Now, let's kindly continue. It won't take long. 33. The joint cadre authority is established. This is important. Apropos, my Lord Chief Justice's comment just now. Joint cadre authority is established under Rule 4 of these rules, which constitutes a committee comprising of representatives of each of the governments. This is state autonomy and federalism. Under Rule 4 of the All India Services, joint cadre for Arunachal, Goa, Mizoram, UT. That is the AGMUT or the AGMUT. AGMUT. Established in 95, whereby Delhi along with Arunachal, Goa and Mizoram is represented in the joint cadre through its chief secretary. This is conclusive, I submit, fellows. That's true of every state of joint cadre. And that is the meaning. Otherwise, states would start saying that we don't want an all India service. We want each state will have its own service. But just give me 30 seconds. This is important. If your lordships were to be persuaded to hold that you can't have this joint cadre and then you allocate it to a state and he works it within the state himself, then state would say, why should you have an all India service? The all India service is appointed to me. He will work under the direction of the All India Master. He will be transferred as All India Master. What a point of having, then I'll have my own service.
Yes, Dr. Singh.
The IAS cadre rules of 54 define state to include UT. Further, mark this. I'll be showing this rule to your lordships. State to include UT. So one is Chief Secretary of my UT sits on the joint cadre. Two is state includes UT. Further, state government concerned in relation to a joint cadre has been defined to mean joint cadre authority. As per IAS cadre rules of 54, once an officer is allocated to a UT, the mandate of posting falls within the jurisdiction of the state government concerned, which in this case is NCT. The two questions of my Lord Justice Chief Justice and Justice Shah. Therefore, by virtue of having the authority to allocate the postings of officers, where and in what department those officers will serve, is also within the executive competence of NCT. Rules 2 must just come straight away to 2 brackets C below. State means the state specified in the first schedule to the Constitution and includes a UT. State in relation to a joint cadre means the joint cadre authority. Postings, all appointments to cadre post shall be made in the case of a state cadre by the state government, in the case of a joint cadre by the state government concerned. I'm sorry, this is very, very important one, doesn't mind, 7B. In the case of a joint cadre, let's say All India Service, the posting will be by the state government concerned. State government is already above, includes UT. No, already above, it includes UT. Now it will come in 11. 11A. Authority to exercise certain powers in respect of the members of the service, serving in connection with the affairs of the state's
Just
constitution.
1 second, Dr. Singhvi.
I beg.
Just 1 second.
Yes.
All appointments to cadre post shall be made B in the case of a joint cadre
No, state cadre first. By the joint cadre, by the state government concerned.
by the state government concerned. Now, state government concerned is defined up there.
To include the UT.
No. D. State government concerned in relation to a joint cadre means the joint cadre authority.
Yes, correct.
That means posting in the case of a joint cadre has to be by the
Joint cadre authority. In which one all the states are UT. No, 11. In that joint cadre authority, my chief secretary, other states is sitting.
So they will post an officer to the
That joint cadre authority will say, now read 11A.
11A.
Now read 11A. It is represented on the joint cadre authority.
Right.
Now read 11. Authority to exercise certain powers in respect of members of the service, serving in connection with the affairs of the state constituting a joint cadre. This is the answer to my notes very directly. The powers of the state government under the second proviso to 4.2 and subrule 6.2 and 7, 10 and 11 in relation to the members of the service serving in connection with the affairs of any of the constituent states shall be exercised by the government of that state.
Yeah.
Well, it's with great respect.
Very clear.
Your unworkable. I mean, it is not very rocket science that this clause is put there. Manoj. Suppose the Lordship has a reverse clause. How does the Lordship function, make a system work, Manoj? Today, Manoj, this country has had single party governance for 50 years. Today, you have different party governance in different states. Tomorrow, you may have again single party for a while. Will these things change? You will give states the autonomy to decide, Manoj. You have to live and let live. You have to have, all these words are only lectures otherwise. Cooperative federalism, competitive federalism. The reality is, you give me an officer, I can't post him to Department X, I can't post him to Department Y, I can't allocate sewage against water to him. It's as simple as that. As per Rule 2C of the IAS Cadre rules, state means a state specified in the first schedule to the Constitution and includes the Union territory. As per Rule 2D of the IAS Cadre rules, state government concerned in relation to a joint cadre means the joint cadre authority. As per Rule 7, postings are all appointments to cadre posts shall be made in the case of joint cadre by the state government concerned. So, teleological conjunctive interpretation of these four things: 2D, 7, now come to 11. In respect of joint cadres, the powers of the state government under Rule 7 in relation to the members of the services coming in connection shall be exercised by the government of the constituent district. Therefore, the collective reading of 2, 7 and 11 I submit is crystal clear with great respect, shows that in case of the actual postings within the government of the state shall be made by the government of the state and not the joint cadre. The complete scheme which becomes clear from the above is that while it is a joint cadre authority where Delhi has its own separate representative, which allocates officers of the eqnuire or adjunct cadre to NCT, the post in which such officer is posted, deputed, is determined by the NCT. Consequently, within, kindly mark the word within, the government of NCT, the said officer has to be posted from one post to another. It is the government of NCT alone which has the powers and the service rules. This is in consequence with the position that prevails in the states of Arunachal, etc., which are also members of the joint cadre. Further, this is fully in consonance with the position of the civil style, the Westminster style. Similar, now we move from the eqnuire to Danics and Danics. Similar is the position of the Danics and Danics. That as per the Danics rules, while it is the government defined under the rules as the government of India that allocates a member of the service, once that allocation is done, it is the administrator acting on the advice of the council who posts within the NCT. Posting. Every member of the service allocated to an administration shall, unless he is appointed to an ex-cadre post or is otherwise not available for holding a public service, be posted against a duty post under the administration by the administrator concerned. Allocation of, here it is, allocation of members. The government shall from time to time allocate a member of the service to any administration. Next parameter. The scheme, obviously, the administrator has to act on aid and advice. That's the whole scheme. That the scheme that emerges from the above is that while it is the government of India that allocates an officer to an administration, it is the administrator acting on the aid and advice of the Council of Ministers in terms of 239AA, who posts the officers within the government of Delhi. There can be no doubt in these rules, the administrator has to act on aid and advice, because in terms of clause 4, it says, this is your lordship's own constitutional clause 4 on aid and advice. There shall be a council of ministers considered not more than 10%, with the chief minister at the head to aid and advise the lieutenant governor in the exercise of his functions, with the respect to which the assembly has, or any other law required to act in his discretion. Provisions such as the above have been interpreted to mean that the law must specifically and explicitly require the administrator to act in his discretion. Otherwise, he is required to act on the aid and advice. Well, this is very important. He has to act on the aid and advice. What is the discretion is something very different. Appellate, review powers, revisional powers, special powers, special powers. Nawab Rabia said this, and even if your lordship were to review Nawab Rabia and the other matter I am appearing in, your lordship will not be reviewing this part. That is follows on giving you a notice to a speaker, disabling you and then walking off. That's the point on which we are arguing the other matter. So this will remain good law, it's not a challenge. Just by the way. We are therefore of the considered view that insofar as the exercise of discretionary power vested with the governor is concerned, the same is limited to situations where a constitutional provision expressly so provides that the governor should act in his own discretion Unless it says so, what will be aid and advice, bound. Additionally, a governor can exercise his function in his own discretion in situations where an interpretation of the constitutional provision concerned could not be construed otherwise. We therefore hereby reject the contention advanced on behalf of the respondents that the governor has the freedom to determine when and in which situation he would take a decision in his own discretion without the aid and advice of the Council of Ministers. We may therefore summarize our conclusions as 155.1. Firstly, the measure of discretionary power of the governor is limited to the scope postulated, therefore, under 163.1. Secondly, under 163.1, the discretionary power of the governor extends to situations where a constitutional provision expressly requires to act in his own discretion. Here it would be you may have a parliamentary law which says expressly the administrator shall himself decide whether to appoint me to a minority. It may be. That's the express conclusions to this. In the light of this conclusion very quickly was A. Exclusion of entry 41 from the legislative executive can and absence of effective administrative control over those serving in would mean the collapse of the Westminster style of government and the principle of collective responsibility. It would completely negate the purpose of introduction of AA and would in fact defeat the amendment. Seventh schedule has been enacted under 246. Under 246, the term state has been held not to include territory, that is Kanya. In the absence of the phrase, insofar as any such matter is applicable, all entries with the term state in lists 2 and 3 would not have been available to the Legislative Assembly at all. Therefore, the term insofar as such matter is applicable is not a term of exclusion or restriction meant to exclude the availability of entries in list 2 or 3 of the 7th schedule, but is a phrase that facilitates the ipso facto availability of all the entries containing the word state in list 2 or list 3, and in this case, in the Assembly bill. The Balakrishna Committee to the extent it treats is incorrect. I'll leave Balakrishna Committee. Part 14, dealing with services, envisages services of a UT in addition to services of the union and the state. This has been held in Prem Kumar Jain. Bala report finding, which has been relied upon by the Union of India, that Part 14 does not envisage services, is therefore wrong. This is directly wrong. I'll skip it. The Lordship made some observation about Bala. For the above reasons, the Constitution Bench rejected the use of the Bala report as an aid to interpretation. For an acceptance of the argument of the Government of India that entry 41 is not available to UTs and that UTs cannot have services of their own will require not just the overruling of the decision in Prem Kumar Jain, but also disbanding of joint cadres such as AGMUT by the Union of India, as also setting aside large number of provisions of the Jammu and Kashmir Reorganization Act. Malas, to not have a service at all has far-reaching repercussions, apart from federalism, apart from state administration, regional, etc. The actual experience of administration of the UT with the legislatures, namely Delhi and Jammu and Kashmir, two examples with legislatures. Entry 41 is available to UTs with legislatures, and various enactments have been enacted by legislatures of UTs that contain provisions that directly relate to and derive power from entry 41. I've given you a list. Delhi minorities, Delhi Lokayukt, Delhi so-and-so, etc. Union territories can have their exclusive services and public service commissions. The payment of emoluments to all those serving in the government. Now, this Lordship asked me the question early on yesterday. Payment of everything, again emoluments, is part of my annual budget, passed by an appropriation bill of my assembly. It is unimaginable that the assembly or the government of Delhi that is responsible for raising revenue and making payments to those serving in NCT, but the answerability of those is elsewhere. L. Under the respective services, the transfer and posting of to these services within a UT lies with the elected government. Within, that's L. M. While the above position prevails in the UTs with legislatures sufficient for the purpose of NCT or the present case, the position of NCT, given that the legislature are constitutionally mandated and not pursuant to a simple parliamentary law, necessitates effective control over the civil services. It is otherwise necessary to do any implementation of policy. Any implementation of policy is nugatory without my control over my own civil service. It is just a chimera. It is just one of the pipe dream that anybody will listen to me. The exclusion of entry 41 would be contrary to the majority judgment. I have cited that, Lordship is read it, etc. Well, 2 minutes more. Just note Take an example where your lordship has no power in NCT to appoint, transfer, allocate work. Take that. I'll give you lordship 2 or 3 very quick, 1 minute example. Example 1, Malas. I am NCT. I decide that COVID needs me to appoint 100 staff in Delhi government's NCT's 5 hospitals in Delhi. Either I can't appoint, or I can appoint 5, or I can appoint 7. I then decide that this staff is better suited to Safdarjung Hospital or the other hospital which are mine. No, that transfer cannot be by me unless somebody else agrees. Example 2, I am paying suddenly in the middle, suppose for whatever reason there is some event happening. Payment of salaries is delayed, stop. Payment towards rent and staff salaries for running primary health centers may be stopped. Primary health center run by NCT, Malas. No, you are running primary health centers, you have got 100 people, you should have only 20 people. I would pay the salary of the balance 80. Your lordship gets a water treatment plan. For several months, the water treatment plan, which is a policy manifesto, stated that we are going to clean this place. Certain stretch in Yamuna apart, actually. Malas, the bureaucrat concerned says that no, I have to answer to, I can't meet the ministers for this. Malas, I am not going to any affidavit. These are hypothetical examples, but they are real examples, unfortunately. Sorry, I can't meet you. I have already written my report to the LG.
Either he relies upon or he does not rely upon.
Very well.
Because I have an answer.
Now, Malas,
They are
in the light of
factually
this,
incorrect.
I am concluding.
And as per the contemporaneous record, they are incorrect.
Either I am, anyway, let's leave that.
Don't say something and say that I'm not relying upon.
Either I am not living in Delhi or Mr. Mehta is not living in Delhi. Both of us can't be living in Delhi.
But we take it that
No,
what you are
anyway.
giving us are hypothetical illustrations of what may happen if we don't accept your argument.
Please
That's your
take it as hypothetical. What will happen definitely in case I have no power. Let me put it like that. Well, I'm done now is one thing. My learned friend will take by the clock a few minutes to make that point about other capitals and the fact that your lordship actually has the strange irony that you have less power in the NCT than your lordship gives to the municipality. And in the worst example of those capitals, the most centralized, least liberal example, the power of the state government is more than what has been conceded to the NCT. That's 2 minutes for me. Now, I want to end by saying, I'm concluding this. Please see the larger picture. Well, as here is a person who's trying to save his burning house. That is me. I am not trying to go and attack his house. Where is the question of my encroaching upon 1, 2 and 18? I am trying to save what I've got. Number 2, if your lordships were to be persuaded by this argument of competence of the NCT, as raised by the Government of India, it would amount to that I will be left only with areas of incompetence. I have left with nothing. If this is the understanding of a competence, then this elected government is left with incompetent areas only. Number 3, it is something like a gearbox system. The constitutional gearbox of this is those who implement the civil service. You are giving me a gearbox which I can't change. Either I drive in only gear number 1. I can't speed up the car. I can't go to gear 4. All the levers of the gear movement are in somebody else's hand. You give it to me that, look, I have given you a gearbox which is fixed at 1. Well, this system can't work. The car can't move. The people of Delhi cannot benefit. Also, if your lordships were to have this, and your lordships in your experience as administrators also know, that no civil servant will feel that he is answerable in any which way. All these long lectures we are giving about accountability to the minister, minister to the legislature, legislature to the people. He is simply not bothered. The practice of the matter is that you are bothered only about the person who can deal with you, who can transfer you, who can post you. In practice, all the homilies we give, civil servants are very smart people also. They know that I am not to be bothered unless I am answerable to you. Therefore, I beseech my lords that I am asking for a minimalist power, which normally nobody should need to ask for. It is implicit in the very creation of NCT. Otherwise, you should have no NCT. It is implicit in the creation of NCT as a constitutional legislature. What? I can post them. I can decide where to post them. I can allocate work and I can transfer. That's all. I'm very deeply obliged.
Thank you, Dr. Singhvi.